Hi everyone, welcome to ITLS Academy. Myself Advocate Priyanka and I am again here with you with some new patent topics. So there has recently on 15th March 2024 some changes made in the rule that is called Patent Amendment Rules 2024. So in this session we will go through this all rules, what changes have made, is there any change in any fee or any forms. So all the things we will see in this topic. So for this session I have added some contents as usual. So first is highlights of previous session. I will give a very brief highlight of previous session what we discussed in our last session. Then we will see the key features of patent amendment rule, that what are the main changes which has done in this rule, and then we will say there are some if there are some amended forms or there are some newly added forms, and if there are some changes in fee, that we say amended fees. So let's start with the previous session highlights. So in previous sessions we have gone through the topic that how patent registration can be done in India or outside the India. So there are basically three procedures. First is ordinary application, which is for the India applicable. You have to go through the patent searching, and then you can file registration for the application, and then after that examiner will prepare patentability report, and then they will review the application, and after that they will send you their report, and if everything is okay, then patent will be granted and you will get the certificate. Now next is Paris Convention. It is the way to file patent outside the India. In this, first you have to file a local priority application. This local priority application can be your Indian patent application also. And then within 12 months, you can file application directly in each country which you wish to file. And then there is patent cooperation treaty. So it is the most you can say feasible and most popular procedure to file application outside of India. If you have to file application more than 2 or 3 countries, I mean file application in more than 2 or 3 countries. So for this as Paris Convention, you have to first file the priority application, and then within 12 months you can file PCT application. So you can see till here it is the same like the Paris Convention. So within 12 months you will file PCT application, and then there is one extra 30 to 31 month times, in which time you can prepare your documents, and or you can think in which country you can just do some research that in which country your technology will be I mean it will boom, or you will get some economic values. So on the base of that, there is 30 to 31 month times you have to decide that in which country you wish to file. So after not after within 31 months you can file that national phase entry. You can enter in the national phase entry, that is the filing application in particular countries in you wish to the file. Now next, in our previous session we have gone through that if there is any post registration formalities, like for the patent post registration formalities. So yeah, there are some patent registration formalities. So here I am talking in the context of Indian patent application. So after getting the registration, there must be renewal of every patent year till the patent protection period, that is the 20 years. Then second is filing form 27, that is working statement. Basically this form you have to show the patent application that for you which patent is granted to you, is it in working form or is it in working stage or not, because it is obviously any patent is granted which is meant for the public use. So after that you have to must update in the patent register if there is any change in ownership, or you have given license to some other exclusive license or non-exclusive license. So everything should be must updated in the patent register. And there is one more important thing, that after the registration, patent registration, as before the patent registration, you know that anyone can file the patent uh, pre uh, pre grant opposition. So like this, anyone can file also post grant opposition, but it should be filed in the 1 year of patent grant. So these are the basically things which we should keep in mind after a patent registration. Otherwise, if anything you will miss, your patent can be abandoned. Now we will move to our today's topic, that is Patent Amendment Rules 2024. So it basically came in the force on 15th March 2024. So first we will see that some basic key features of these rules. So if we talk about the Rule 38, under this rule there has some changes. So a delay for all acts and proceedings are extendable up to 6 months. Earlier, it was not applicable for the all delays, but now it is applicable for the all delays under the new amendment rule, and it can be for any number of times. Like it's not like that if you have delayed for first 6 months, then you cannot delay for the next 6 months. You can delay it for the next 6 months, and it will be, but that delay must be before the expiry of extended period. Like from today, if you have delayed something for the 6 month, so if you want to delay more than 6 months, then before the expiry of that 6 months you have to file the form for the extension. And request for extension of time, it will be made in the form 4. Yeah, but here I want to mention one thing, that obviously they have a given provision as for the um, extension, that is a very good, but fee is at very higher side. So it is recommendable, or you can say that it is advisable for the patent agents or for the applicants that please don't miss the deadlines, because if you will miss the deadlines, you will have to, you may get the extension, but you will have to pay a higher fee. Now another, if we talk about the rule 13 2A, so according to this, according to this new amendment rule, divisional application can be filed under section 16 by the applicant, including in respect of an invention disclosed in provisional application. Earlier, it was like that divisional application can be filed, but okay, see, we will see this decision first. So this amendment is particularly in line with the decision of the bench of High Court in Syngenta case, that clarified that divisional application can be filed as long as the plurality of invention disclosed in the either claim or a specification. So here I was telling you that according to the new amendment rules, divisional application can be filed on the basis of provisional application also. So in generally what happens in provisional applications, applicant don't give claims, because till that time they don't have any particular claim. Sometimes they give, but sometimes they don't give. And it is completely acceptable. But if anyone wants to file some divisional application on the basis of their provisional application, then how will they file? Because in generally we say that inventions or included in the claims only will be is the main invention, and on the basis of that only divisional applications can be filed. But now it is clear that no, it is not that the inventions disclosed only in the claims, even invention disclosed in the specification also will be considered as the base for filing divisional application. So now if you have filed a provisional application and that time you don't had any claim, but you want to file some divisional application on the basis of provisional application, obviously you can go and file. Now next is rule 24B1. So this is basically about the reply to first examination report. As we know that after the submission, after the filing of our applications, examiners do their patentability requirements. For that, we need to file the form. Prior to that, they will not start your examination of the application. So Earlier it was timeline for filing the RFE was 48 months. So there was a very sufficient time, you can say, but in other way you can also say that because of this patent grant was also delayed, because applicants, most of the applicants, when they are not determined that they should proceed further or not, they file on the 47 months, 46 months, or sometimes they don't file. But now it is reduced to 31 months. So obviously you have little bit less time, but if you file on the time, your patent will get grant more earlier than the previous applications. So before it was 48 months time for the filing RFE, but now it is 31 months time. And this rule will be applied patent application filed after 15th March 2024. As I told that this rule came in existence on 15th March 2024. So if any patent application filed before this time period, then they will still follow this 48 months time duration. But if it is filed after 15 March 2024, then only they will follow the 31 months time duration. So these things we have to keep in the mind that when we file our patent application. Now there is rule number 22 and 12.2 and 12.5, that is regarding the statement and undertake regarding foreign application, that is form 3. So what happens in Indian patent system, we have to give information to the controller that for which application is filed in India, and if it is filed outside the India also same application, then we have to give updates to the Indian Patent Office regularly that what is happening in that country on their applications. So this was earlier that filing of first form 3 every 6 months we have to file, but now there are some changes, so we will see what are the changes. So filing of first form 3 remains same, that is first form 3 should be filed within the 6 months of the patent application in India. So here you can see there is no change, like if you are filing for form 3 first time, then it will be the same like I told, 6 months. So form 3 should be filed within 6 months of the patent application in India. Like if you file today any patent application in India, then within 6 months you have to file this form 3. But after that, in earlier rule, it was the same 6 months, that on every 6 months period we have to file the form 3, either there is any change in status of the foreign application or not, it doesn't matter. But now the next form 3 should be filed within 3 months of the issuance of first EER. So that means now we don't need, or patent agent or applicant don't need to file form 3 every 6 months. Now they are required to file form 3 only when their FER is released and within the 3 months from the release of FER period. Earlier it was filing every 6 months, which I explained only. Now rule 12.3 and 12.4. According to this new amended rule, controllers shall consider all the information relating to prosecution of corresponding foreign application that are accessible using public database. That means the controller, like we are now we are not filing form 3 every 6 months. So in this case, if controller wishes, she can use the public database and she can see that, or he can see that what are the updates in the foreign applications. However, if controller wants, he may direct in writing with the region that what the region he is wanting to applicant to submit an updated statement and undertaking in form 3 within 2 months from the date of communication from the controller. Like we don't need to file form 3 every 6 months, but if controller wants, then with the specific reason why he wants, he will write the applicant to submit the form 3, and that time period will be submission of form 3 time period will be date of communication from the controller till to 2 months. So within the 2 months from the date of the communication from the controller, patent applicant should file the updated Form 3 if controller tells them. Now there is Rule 55 and 56 which tells about the pre-grant and post-grant opposition. So according to the amended rules, now there is a charge of INR 20,000, or you can say $250 for filing a pre-grant opposition. And the timeline for replying to the opposition period notice is reduced to the 2 months. Earlier it was 3 months, but obviously extendable by 6 months according to the Rule 130. That means if anyone is opposing your patent application before the grant, then in that case controller will send you that this opposition came to you, and then you have to file the opposition notice, I mean reply to the opposition notice to the controller within 2 months from the communication from the date of the controller. Earlier this time period was 3 months, but now there is one change that it can be extended by the 6 months according to Rule 138, which we discussed in our first rule only. Now for post grant opposition, the timeline of opposition period to gives its recommendation is reduced to 2 months. Here also it is the same, it is reduced to 2 months from the date on which documents were received, and earlier also it was 3 months. Now we will see that Rule 131.2, that is Form 27. So basically what is the Form 27? If you remember that what are the post grant formalities, there I told you that what is the Form 27. Form 27 is basically the annual working report form. That means we have to show the Indian Patent Office like what's the progress, is your application, is your invention is already in the working stage or not. If it is not, then what is the reason? These all things we have to file after the post grant. So there are some changes in this also, like earlier it was to be filed in respect of every period of financial year. Like every year we had to, or patent agent had to file this Form 27, but now this time is changed to the 3 financial year. That means within the every 3 financial year you have only to give the update about the working report in the Form 27, earlier which was every financial year. So also I think this is the good initiative to less the burden on the applicant or patent agents. So now you don't need to file this Form 27 every year. You can file this, or you have to file every 3 financial year. Now there is Form 31, that is for the grace period. So as we know that in the for the form, for the any application which came in the public domain, you have 12 months time to file still to file the patent application if your invention or if your application is anticipated by the public display. So for this Form 31 is introduced, and with this form you can avail the grace period of 12 months of time from the patent office for the your application which has been anticipated by public display. Yeah, but here you have to obviously give the particular reason. Now there is Rule 137. So according to this rule, controller has power to correct irregularities in procedures and amend documents regarding to that procedures. But now under the new patent amendment rule, there are following acts which has been specifically excluded from the controller's power. That means now they can't make any changes by alone on this particular acts. So what are these acts? Request for national phase entry. So the here control can't correct irregularities in procedures or amend documents. So obviously there are some other procedures Now there is filing of an English translation of international application, filing a priority document, filing a request for examination, uh, filing reply to office action, filing reply to pre-grant opposition, payment of renewal fee, deadline for filing review petition, extension beyond 6 months for filing the working statement. Like there can be extension of everything for the 6 months, but here if we talk about the working statement, that is the form 27. So now that controller has not power alone to decide that they can extend beyond 6 months for filing form 27. So these are the acts on which controller's power has been limited. Now there are some other procedures or some other things which we will obviously discuss later about this things. If there are any irregularities or there is some documents need to be amended, all things now controller can't decide alone. Now we will see that our next topic of this session, like if there is any amended forms. Yes, there are amended forms like form 1. Here we have to include age and gender of applicant. That means in that form one column is added to include age and gender of applicant and or inventors. So earlier this column was not in the form 1. Now include email address and contact number of the applicant also. So earlier this was also not like this, contact number of the applicant must be in the form, but now this column has been added. So these are the changes in form 1. If we talk about the form 3, there is also some changes, like date of grant column is replaced with the column of disposal. Like I think it is only the meaning that is changed, that earlier it was told at the date of grant, now it is described at the disposal. And now if we talk about the form 4, which is specifically used for the extension of time, so it lists all relevant provisions for extension of deadlines or condonation of delay. Like means it is not like that for the particular thing only form 4 will be used. Irrespective of that, it will be used for the extension of deadline for the all related provisions which is discussed in the rule number 138. Now if there any next topic was that if there any newly added forms. So yeah, there are some newly added forms like form 8A. This form is added for the if you want to wish to file for the certificate of inventorship. Earlier this certificate of inventorship was not given, so this form was also not there, but now this certificate of inventorship is given, and for this form 8.1 is included. And I think it is a very good initiative, because sometimes what happens, inventors are not the applicant if they are working under any organization or that things. Then in that case, obviously if they will give the reference of the patent, that there I am the inventor, but now they will have their own certificate for the particular patent, that yes, for this application, this patent, I was the inventor or we were the inventor, and for that they will get the certificate of inventorship. Now form 31, as we discussed already, it is form to avail grace period of 12 months for any patent application which is already anticipated by public display. So in that case, you can avail 12 months of your time from the Indian Patent Office from the date of the anticipation of your application in public display. So within 12 months you have to file that patent application, and from this form for this form 31 is introduced. Now we will see the if there are any changes in fee. Yes, there is of course some changes in the fee. So we will see that what are the changes, like extension of form 3. If you wish to file, if you wish to extend your form 3, like I told that now there are changes. Earlier it was extension of form, there was no, earlier it was form 3 to file every 6 months, but now you have to first form 3 file in within the 6 month from first application, filing of the application, and then after the getting report of FER within the 3 months. And now there is provision of extension of that also. Earlier it was no provision, but now it provision, but obviously as I told that it is with some fee, so it is 10,000 per month. Extension of form 27 we discussed. So earlier there was no provision for the extension of Form 27, but now it is, and it is 10,000 per month. Any other extension under Rule 138, earlier it was 8,000 per month, but now it is can be go to the maximum 50,000 per month. Pre-grant opposition, there was no for the filing pre-grant opposition, but now it is it is payable. So it is 20,000 per month. So of course now if you want to oppose, or your rival company wish to oppose, they first need to pay the fee. It is not like that anyone can come and just file the pre-grant opposition. Obviously they can file, but for that they need to the pay money, and that is 20,000 per month. Post grant opposition, earlier it was 12,000 per month only, but now it is increased to 40,000 per month. So in this case also, if there will be some genuine the genuine opposition, then only I think there will come post grant opposition. So I think this decision has been made for to reduce the application from the pre grant and post grant, because if there is no fee, then obviously we think that okay, if there is no fee, what is going to us, we just go to the file the form and we can file for the pre-grant opposition. Even in the post-grant opposition there was fee, but it was not very high, it was 12,000, but now it is 40,000. So obviously if anyone will go for the filing post-grant opposition, first they will see their genuine backgrounds, their genuine reasons, then only they will go for the post-grant opposition. Now patent surrender. So earlier if you wish to surrender your patent, there was a fee, that is 5,000 5,000, but now there is no fee. Grace period, there was no provision like for the grace period, no particular form for the grace period like 12 months, but now there is provision, and you can file with the form 31, and there is a fee also, that is INR 2,500. It is one time applicable, because it will be given to the for 12 months period for one time only. Now certificate of inventorship, as I discussed earlier that there was no certificate of inventorship before this amendment, but now this is added, which is added benefit for the inventors also. But it is payable, but it is not very high, it is only INR 900. So with this 900 only you can file certificate of inventorship in the form 8A. Advance payment of renewal fees, like if you any applicant wish to file advance payment of renewal fees, so earlier there was no provision that there will be some reduction or something like that in your fee if uh, you are paying advance fee for the some, here as like this, it is at least should be the minimum 4 years. But now if you pay the renewal fees at least for the 4 years at one time, then there will be 10% reduction in your fee. Now request for mention of inventor. So earlier there was some fee for that was 2,000, but now there is no fee. So these were the basically some key changes or key features of patent amendment rule, and we have gone through that what are the changes, what forms we added, and what are the fee amendments, not what forms we added, sorry, what forms this new rule added, and then what are the few fee changes, amended fees, and what are the some amendments in the forms also, like in form 1, form 3, so and form 4. So these things we discussed today. So I think I have covered all the essential changes what were done in the patent amendment rule 2024. But if in case I miss anything, you can write in the comment, I will go through that also. And in previous session, we have discussed about our patent filing, and I told that in next session we will discuss about the new amendments in patent rule and then patent infringement. So here now time is not giving me permission to go to the another topic, that is patent infringement. But obviously I will come with this topic in the next session. It is also a very vast topic, and then we will also see that what are the international treaties for filing the international patent application. So next topic will be about the patent infringement and international treaties for patent protection. So if you are curious to know about these topics, Obviously it will be more entertaining, like if anyone is stealing your invention, then what can be done, and what are the international treaties, and what are their contribution for filing the international patent application. So these all things we will discuss in our next session. So I hope I have cleared your all not your all, I think I can say that I have cleared all major changes in the Patent Amendment Rule 2024. As I told earlier, I am telling it again that if I missed anything, don't hesitate to write in the comment section. And see you in the next session with some new topics. So thank you so much. And if you have any doubts regarding any topic, you can write. I will come with the doubts clearing sessions also. So thank you so much for watching me, and please don't forget to follow ITLS Academy on Instagram, Facebook, LinkedIn. In one line, I can say that you can find ITLS Academy on social platforms, on learning platforms. So just go and subscribe and follow ITLS Academy, and you will get more sessions, more topics which are associated with ITLS Academy. Thank you so much for watching, and hope to see you all soon in with our next topics in next session. Thank you so much.